For over a year, the fight against marijuana reform has run on one accusation: follow the money. Washington only rescheduled weed because the cannabis industry paid for it. On July 2nd, two of those groups took that argument to a federal court. And to make it, they had to show the judges their own books. It backfired. Start with what actually happened. In April, Acting Attorney General Todd Blanche signed an order moving FDA approved cannabis medicines and state licensed medical marijuana out of Schedule 1 and into Schedule 3. A coalition sued to kill that order. Prohibition groups, two state attorneys general, Kevin Sabet's smart approaches to marijuana, the heavy hitters of the anti weed world. But when it came time to ask the court to freeze the reform while the lawsuit plays out, most of that coalition sat it out. The emergency request came from exactly two parties: a drug testing trade group, the National Drug and Alcohol Screening Association, and a pharmaceutical company that has never sold a product. The government's answer was short. These two, it wrote, come nowhere near satisfying the standard for that kind of extraordinary relief. Then it explained why. Both of them invoked pocketbook interests, served by keeping all marijuana in Schedule 1. Here is why that line lands the way it does. For over a year, the case against reform has run on one idea, and Sabet has pushed it hard, including in a video he posted the day the DEA hearing opened. The government didn't move on marijuana because the science changed. It moved because the industry wrote checks. The July 2nd brief never mentioned Sabet by name. It doesn't have to. Read it against that year of messaging, and it turns the accusation around. If this is about money, the government is asking whose. The answer is in the challenger's own paperwork. The screening group told the court that its members would lose money if employers stopped testing for weed. In a sworn declaration, its executive director said marijuana positive results are the single largest source of revenue at the medical review offices that read those tests. Take weed off the panel, he projected, and revenue drops at least 35% inside a year. Then the group put a dollar figure on what compliance would cost: roughly $700,000, spread across 700 employers. Do that division. It comes out to $1,000 per employer. $1,000 per employer. That is the injury the group called irreparable. A cannabis lawyer who read the motion did the same math and called it ridiculous. The pharmaceutical company's claim is stranger. It says it spent 8 years and $10 million developing cannabinoid drugs the slow way through the FDA. And it says rescheduling rewards the state licensed competitors who skip that path. Here is the problem the Justice Department pointed out. The company has no product on the market. It has applications pending, not medicine on shelves. You cannot lose your share of a market you never entered. What the company described, the government argued, is a policy it dislikes, not an injury a court can fix. Then the Justice Department reached for the doctrine that does the real damage. Lawyers call it the zone of interests. Even if these groups could prove they would be hurt, the government argued, this is not the kind of hurt the Controlled Substances Act was written to stop. Read the brief. Congress passed that law to regulate substances for research and medical use. It did not pass it to guarantee drug screeners a permanent income stream for testing weed, and it did not pass it to protect market opportunities for cannabinoid drug developers. A testing lobby and a company with nothing to sell are not who the drug laws exist to protect. Their injuries, the government wrote, fall outside the statute's zone of interests. On standing, the government was just as blunt. The screening group never named a single member with a concrete injury, just general speculation about the industry. And the harm it predicted runs through employers, third parties who aren't even in the case, deciding on their own to drop marijuana from their testing. Any extra cost, the Justice Department said, traces back to the screener's own billing choices. Harm you bring on yourself does not get you into federal court. The D.C. Circuit already said so. If this feels familiar, it should. Across the river in Arlington, inside the DEA's rescheduling hearing, a proceeding the agency packed with opponents, these same groups have spent most of their energy attacking the government's scientific test, not what it found, because the medical use finding is the harder ground to fight on. Their stay motion does sound the public health alarm. Warnings about teenagers, warnings about addiction, and the government's answer is that none of that is an injury the law lets them sue over. Inside the hearing, The fight is about the science. In court, once you strip the motion down to the harm a judge can actually act on, it reads like a balance sheet. None of this means the challenge is dead. The petitioners still have a real argument on the merits. It rests on a 1977 D.C. Circuit case that held the Attorney General can only use the treaty shortcut as far as the treaties actually require, and has to get a binding medical and scientific recommendation from Health and Human Services before rescheduling. That fight is legitimate, and it isn't going away. But a stay is a different animal. Under the Supreme Court's four-part test for freezing a policy mid-case, anyone who wants that freeze has to show they will suffer irreparable harm without it. In the DC Circuit, that isn't optional. It's the price of admission. The two groups showed up to prove that wound. What they handed the court was a profit and loss statement. The judges are expected to rule on the freeze in the coming weeks. The full case will take a lot longer. But the record already holds the thing that matters. The two groups asking a court to keep marijuana in Schedule 1 have, in their own sworn numbers, a commercial stake in that outcome. So here is what to actually watch. When the ruling drops, skip past the public health language and go straight to the harm section. That is where a stay is won or lost. If the strongest injury two groups can name is their own revenue, the freeze is in trouble, and rescheduling stands while the real fight moves to the merits. If you want to follow that fight as it happens, hit like and subscribe. This one is not over.